Yes, good morning, Mr. Beer.
Good morning, my ladies, my lord. We appear before you today with the permission of the late Lord Justice William Davis. I'm assisted by Miss Wolfe in representing the interests of the first appellant, the Chief Constable of Sussex Police, whom I shall call the Chief Constable or the Police, and Mr. Talalay, who sadly cannot be with us here today. Miss Barton, King's Counsel, appears on behalf of the second appellant, the Crown Prosecution Service, the CPS, assisted by Mr. Goss. Miss Murphy, King's Counsel, and Mr. Powell appear on behalf of the respondent,
Yes.
who benefits from an anonymity order
Yes.
and is known as XGY, with her former partner known as DYP, albeit the judge referred to him as K in his judgment,
Yes,
and whose anonymity is necessary in order to secure the anonymity of XGY.
And I'll let you finish the introductions, and then I'll say a little about the anonymity order.
Thank you. I was going to say that the anonymity order made by Her Honour Judge Brownhill, no need to turn it up, it's at supplementary bundle 189 and 190, provides that not only in the proceedings themselves, but in any report of the proceedings, the respondent shall be known as XGY and her former partner as DYP, and that there should be no reporting of any information which may lead to the identification of the respondent. That order was continued for the purposes of the appeal to the High Court. That's the order of His Honour Judge Blom, King's Counsel, Supplementary Bundle 181, and by Lord Justice Davis in the grant of his permission, Core Bundle, page 213. But we understand that the broadcast of these proceedings has a delay built into it so that it is not live.
Yes, and I'm just looking for, yes, and I have a pause button in the event of any difficulties arising, but yes.
Yes, so that the remedial action may be taken
Yes.
if one of the advocates in this court make a mistake.
Yeah, it's extremely unlikely, but absolutely, we are set up for that. There are no members of the press here. There's been no objection to a continuation of the anonymity order made by Her Honour Judge Brownhill and continue thereafter, as you have identified. And so that order will continue for the duration of this hearing and thereafter until further order.
Thank you, my lady. Finally, Mr. Waterman, King's Counsel, and Miss Collier intervene with this court's permission on behalf of the Bar Council. In relation to the timetable for submissions, you should have been provided, in accordance with your directions last Friday, a written representation of what has been agreed.
Yes, we have that. Thank you. It obviously very helpful for you to have liaised with that. And you're filling the 2 days, and we'll see how we go. We would also like to break at around 11:45 in the morning for 10 minutes, and again at 3:15 or thereabouts for another 10 minutes, depending where you are in your submissions and when it's convenient. But short mid-morning and mid-afternoon breaks as well.
Thank you very much. I should say that for the Chief Constable, Miss Wolfe is making submissions on our ground 5.
Right.
The standing issue and victim status for the purposes of Section 7 of the HRA and the summary judgment application, and so she will therefore follow me.
Well, we are always delighted to hear from the junior bar as well as from the front row.
I think Mr. Goss is doing the same on behalf of the CPS.
Very good. Thank you.
We've also spoken with Miss Barton and her team in relation to the order in which she and I should make submissions, because it's plain that there's some overlap, so as to ensure that there's not proper duplication. We've agreed that I should go first, in part because a number of the submissions which I propose to make in relation to the Chief Constable's position also have force in relation to the appeal of the CPS, and in part because there are criticisms with respect to the judge of the entire approach that he took to determining whether an immunity or immunities apply to the conduct of the appellants, and those criticisms apply to both appeals. I think rather optimistically in terms of bundles, that the bundles are all in order.
Yes.
You have quite compact core bundles, split into core bundles 1 and 2, and a modest, in the scheme of things, supplementary bundle. We've tried to pare it right down. But reflecting the fact that this appeal principally concerns issues of law, and on our case, a rather significant departure by the judge from the conventional way in which immunities from suit operate and are applied, it's been necessary to provide the court with 5 bundles of authorities spread across, I think, 4 volumes. The hard and the soft copy pagination match, so I'm
That
only...
is excellent. I think my lady may be working, I think we're all working on a hybrid basis.
So I'm going to
that
call
is-
out
that
one
is very
number
good. You can call out one number.
and it will match. I will call out tab numbers as well if some of you are working from hard copy.
Thank you
because
very much.
That's much easier. I suspect you'll have a loose bundle of material from the Bar Council containing, most significantly, the written submissions of my learned friends within the bundle, within their pages 10 to 27.
Yes,
The witness statement of Dr. Van Dellen at pages 42 to 54.
Yes.
And then 3 additional authorities from page 81 onwards.
yes.
That's the material. Lady, I'm going to dive straight in, if I may. Ground 2 is where I'm going to start, our ground 2. I'm going to begin with ground 2 because it's the most straightforward. It's where, with respect to him, it's most clear that the judge went seriously wrong. And because it provides him our submission, the court with the most neat and direct way in which the appeals of both the Chief Constable and the CPS may be allowed. Can I start, please, with paragraph 112 of his judgment? That's core bundle 1, tab 13, page...
So your ground 2 is different to Miss Barton's ground 2. So just reminding ourselves, you're just going straight in for the immunity from suit point.
Yes.
Not suitability for strikeout or anything like that.
No.
Thank you.
So it was core bundle 1, tab 13, page 200.
Yes. Yes.
And it's paragraph 112 of the judge's judgment, where he says that he's considered Her Honour Judge Brownhill's ruling that the claim against the police could not succeed because it was parasitic on the claim against the CPS, which was barred by advocate's immunity at court. This rests on the conclusion that the damage was only caused when the address was disclosed, and that only occurred in court. Factually, that appears to me to be correct in relation to causation of injury and loss and damage, and he notes that no declaration was claimed. The judge therefore correctly, in this part of his judgment, held that the claim against the Chief Constable only crystallised when the CPS's advocate made the disclosure in open court. Put another way, the disclosure by the police to the CPS didn't cause any harm. As a matter of causation, that was a dead letter. In order for the respondent to succeed against the Chief Constable, she must first succeed against the CPS. Now, the respondent has not cross-appealed against this part of the judge's decision, and nor has the respondent, by her respondent's notice, sought to uphold the judge's decision on the different ground that this part of his judgment was wrong. And so this means we've a direct interest on behalf of the Chief Constable in the CPS advocate being immune. And that's why I start with this.
I absolutely hear what you say about the procedural position, which appears to be right. However, it's right that I should express my own reservations about the correctness of this approach when it comes to looking at immunity. Immunity is attached to the acts. The policy reasons underpinning the reasons for immunity are about inhibiting or fettering the acts of the advocate or police officer, not looking at harm at all. So what is going on here? And Her Honour Judge Brownhill took a slightly different approach and talked about the chain of causation being broken, I think. That, again, seems to me to be a very difficult analysis because the CPS handed over the information in question for the very purpose of it being deployed in court if necessary or entirely foreseeably. So I just voice those reservations. It may not matter at the end of the day. And I hear what you say about the procedural position, but those are my thoughts at the moment.
Yes, I'm not making a point that the immunity attaches to the harm caused. My lady is exactly right, that it's about the conduct in question. The point that I take, I mean, I've said it already, I can't improve upon it, As a matter of fact, the case is put on the basis that the harm was caused by the CPS disclosure. It was disclosure by the CPS to DYP that caused the harm,
I see.
not by the police to the CPS. One can think of an entirely different situation. I think of the case of Cliff Richard, where the police wrongly disclosed information to the BBC, and there was an inherent harm in that, police disclosing information to journalists, irrespective of what they might do with it. Both were liable for the police and the BBC for misuse of private information, subsequently for the disclosure by the BBC, whereas here there can't be any harm in the disclosure from the police to the CPS. Now, the judge considered the matters the other way round. He first considered whether there was an immunity which related only to the police's conduct. And I'm going to come to that in due course. That was paragraphs 108 to 111 of his judgment. And then from paragraph 113 onwards, he turns to the immunity of the CPS, with the link between his ruling on the CPS and the police being that critical paragraph 112. I'm not going to spend time showing the court the authorities which establish the immunity of the advocate in relation to things said by them in the course of judicial proceedings within a court. That's been addressed comprehensively by the CPS in its skeleton argument and by the Bar Council in its skeleton argument. And as I anticipate, will be addressed by each of them in their oral submissions. And there's no point in me duplicating that prospectively. Instead, can I address the judge's reasoning for holding that the conduct of the advocate in this case was not arguably protected by the advocate's immunity? As best we've been able to work them out, there seem to have been 4 reasons which moved the judge in holding that the conduct of the advocate in this case was not arguably protected by advocate's immunity in court. First, that the immunity only applied when words spoken by the advocate related to the evidence to be heard at a trial, or possibly, on one reading of his judgment, related to the evidence to be heard in the course of a preliminary hearing, including a bail hearing. His second reason appears to be that the way that the function was performed by the CPS advocate did not protect XGY. Instead, it endangered her and was therefore contrary to the main justification for the advocate's immunity at court, as he identified it.
Sorry, therefore contrary to the
main justification for the existence of the advocate's immunity of court, as he identified it. Thirdly, that imposing liability rather than upholding the existence of an immunity would make the CPS better advocates, because they would think more carefully before they disclosed information in court if the prospect of them being held liable was a real one. And fourthly, the upholding of the existence of the immunity would wrongly facilitate and protect muck-ups. Now, the judge's move from absolutism to his new phrase, justificationism, not only allowed him to open the door to those second, third, and fourth points that I've just identified in relation to the CPS, it infused and polluted the entirety of his reasoning. I'm going to, however, take the points in the order that the judge seemed to, 1, 2, 3, and then 4. So justificationism applies to reasons 2, 3, and 4. The first reason, advocate's immunity at court only relates to evidence. This is his paragraphs 113 and 114. You should have that still open.
Yes, we do, thank you.
On page 200 and 201. Now, this seems to be an independent reason for the judge, i.e. independent from his justificationism approach. It's more about the lines that he drew around the advocate's immunity to establish the four corners of the advocate's immunity. The judge, as we understand him, is best understood as meaning that the immunity only applied when the words spoken by the advocate relate to the evidence to be heard at trial, or possibly evidence to be heard in the course of a preliminary hearing. And therefore here, what the CPS lawyer said in his advocacy, seeking the imposition of a bail condition, was extraneous. Now, I anticipate Ms. Barton and Mr. Waterman will address the reach of the advocate's immunity at court when they make their submissions, and I'm not, therefore, prospectively to duplicate it. But I would ask the court to look at a couple of cases to see how the courts have very recently, in different contexts, treated this idea of when something is extraneous to the proceedings, when a statement is extraneous to the proceedings. Can we start, please, with Smeaton and Butcher? That's Authorities, Volume 1, tab 16. Page 305, electronic. It might, in the scheme of things, be a lesser-known authority to the court. It certainly was to me. So could I just ask the court to read the head note to itself?
So unless it had no reference to the subject matter of the proceedings, is that
Yes.
the focus of your submission?
Yes. And if we can go, if the court's finished with the head note and the holding, to the body of the case itself. If we start, please, at paragraph 24, which is on page 312. And it's a passage from Mr. Justice Holman's judgment below to see what the appeal was focused upon. It's the first part of his passage. His Lordship said the importance of giving a, quote, very wide and comprehensive application to the concept of the statement having reference to the inquiry is reinforced by the modern scope of the categories of people and statements to which the privilege and immunity extends. And then if we see what the Court of Appeals said about that, if we move on to paragraph 26, having reviewed the authorities, the court said, I would express the principle in this way so far as is relevant to the issues in this appeal. A statement by a witness or prospective witness, whether made to a solicitor for the purposes of the preparation of a statement, proof of evidence or affidavit, or made in a statement, proof of evidence or affidavit, is absolutely privileged unless it has no reference at all to the subject matter of the proceedings. I appreciate at the moment we're in CPS advocate immunity at court territory, and this is witness immunity. I'm focusing on these phrases at the moment, the line drawing exercise of the referability of the statement in issue to the proceedings. And his Lordship Lord Justice Clerk, giving the judgment of the court, with whom Lord Justice Latham agreed, says, 2, in deciding whether the statement has any reference to the subject matter of the proceedings, any doubt should be resolved in favour of the witness. Now, this contrasts very starkly to the approach taken by the judge here, both in relation to the advocate's immunity and that which applies to the police service, who drew the line on whether an immunity is engaged by stating it must be the evidence given at trial or relate to the evidence which would in the event be given at trial before the immunity could bite. His four corners were very narrow indeed. And secondly on this, can I draw the court's attention to a very useful application of the test by Mr. Justice Warby, as he then was, in Iqbal and Dean Manson solicitors. This is an advocate's immunity before court case. This is Authorities, Volume 2, tab 33, page 847. To get into the case, if we can please look at paragraph 2 to see what the case was about on page 848. And I'd also ask the court to read paragraph 4 on the same page, please.
I'm afraid your confidence in the page numbers that you're giving me relating to the electronic bundle was misplaced, but there we go.
Well, I apologise both for the error and for my misplaced confidence. Does 847 not have, in the authorities bundle,
847,
Iqbal and Dean Manson?
847 in the, if one uses the electronic references, 854. But there we go. Don't worry.
I hesitate to say this, but I think it's you, not us. Because the other advocates in court are literally and metaphorically on the same page as me.
Well, I'm going to see if I can leap to my lady's defence. Here we go. Let's see what happens. I'm afraid to say, my lady, that 847 works for me electronically.
There must be a problem with my bundle.
I'm so sorry that this has happened.
There we go.
Thank you. Yes, paragraph 2 and paragraph 4.
Paragraph 2 and paragraph 4, just to get into the case.
Oh, I see. Yes, at the bottom. Yes, I see.
And then if we go forward, please, to paragraph 14.1, which is on 850 for most of us, we can see what the issue was. Was the judge wrong to reject the defendant's contention they were immune from suit and harassment in respect of the 6 relevant...
So paragraph 40...
14 brackets 1.
14.
Yes, 14 brackets 1. You can see what the judge, Ms. Justice, will be framing the issue. And then from paragraph 39 onwards, his lordship set out the law. But can we concentrate, please, on his paragraph 65 and 66, which are on page 870. So in 65, he highlights Munster and Lamb, which we're going to return to later today, and adds the emphasis in the Master of the Rolls, Lord Brett's judgment. Nevertheless, insomuch as the words were uttered with reference to the course of the judicial inquiry. And then an older case, I think, of Seaman and Netherclift, highlighting the words of Chief Justice Coburn. If a man, when in the witness box, were to utter something having no reference to the cause or matter. And then his lordship's finding, essentially the ratio of the case, is at 70 on page 871. These citations have a clear and consistent message. If a statement is made on an occasion which is in principle protected by privilege, and it has some reference to or connection with the proceedings, it will fall within the scope of the privilege. A statement which is wholly extraneous to and has no reference to or connection with the legal proceedings in question will fall outside the privilege.
You've taken us to authorities which include the phrase reference to. Are there any authorities which speak of or connection with, or is that a potential extension?
I'll have to, before answering immediately, check the position on that, and I'll come back to the court.
All the cases so far have talked about reference to.
With reference to, yes. I mean, in fact, I think that extension wouldn't affect the principal point that I'm making, because the judge's four corners say that it needn't, it's not sufficient if it has reference to the proceedings. It's got to be either evidence or about the evidence. It's got to relate to the evidence. This is a qualification that, as far as we can see, is from nowhere.
In relation, I mean, a lot of these cases refer to defamation, obviously. And the example that's normally given of something which would fall outside the scope of absolute privilege would be somebody talking about a different case entirely, or trying to use the privilege which otherwise cloak the proceedings to talk about a different matter. In other words, something not related to the case. And those are the examples that are classically given. Somebody just stands up and shouts about something completely different.
Yes, and when we get to some of the other cases concerned with the extension to the witness immunity, we will see exactly what my lady has said, i.e. a further explanation of what extraneous really means. And we'll come back to those a little later this morning. So these set out the test, we say, for when an immunity attaches to statements made in court, whether the statements were made with reference to the subject matter of the proceedings or have some reference to, or in fact, or connection with. To answer my lady's question, you can actually see that in his lordship's judgment at 70, connection with third line.
I'm just querying that, that's all. Yeah.
Oh, you were querying where that had come from?
Yes,
I see,
exactly.
I see. Opposing bail or seeking the imposition of bail conditions is a core prosecutorial function in the course of criminal proceedings. The fact that the information or evidence used in the bail proceedings may not be disclosed for the purposes of the criminal trial, or the fact that it might not be said at trial, adduced in evidence in some way at trial, is entirely irrelevant. Indeed, the whole purpose of bail applications is the protection of the public. Why should the immunity be framed by reference to later events that may or may not occur at a trial, i.e. something adduced in evidence?
Well, it's a purpose of bail, not the whole purpose. There can be different purposes, but a purpose.
Yes, a significant purpose of bail is the protection of the public. And I would say the policy reasons for acting fearlessly are arguably most pronounced when engaged in a bail application for that reason. Can I turn to the judge's second, third, and fourth reason? So the first reason was essentially a line drawing exercise. The second, third, and fourth reasons were all founded on his concept of justificationism. And can I start with that as a concept? Because, as I've said, it infused and, with respect to him, infected his ruling from start to finish. The judge's approach was that in each case it was necessary to see whether an immunity that may exist could be justified when it was applied to the facts of the case before the judge, and that was wrong. Can we see the building blocks, please, with which the judge built his new idea? And that starts back in the core bundle, back in the judgment, page 149. Tab 13, page 149.
Paragraph, sorry, paragraph.
149.
Thank you.
And it's paragraph 21.
You mean page 149?
Yes, I'm so sorry. Page 149, paragraph 21.1.
Thank you.
And I'm essentially going to take the court through the parts of the judgment where the judge builds up his justificationism approach. 21.1, what is the scope of witness immunity before court and legal proceedings immunity before court? Arguably, did the scope fall short of applying to the police actions in passing the appellant's confidential Hampshire address to the CPS without a direction not to disclose it to DYP? Arguably, did the scope fall short of covering the actions of the CPS in disclosing the address to DYP in court? Arguably, if the scope did cover the action, should the immunity be granted? Absolutely. Or was an analysis of the justification for the immunity required before deciding whether to grant it? In passing, it's not clear why the judge's witness immunity before court and legal proceedings immunity before court might be thought to cover the actions of the CPS in disclosing the address to DYP in court. You'll see that his heading doesn't really match to what follows, which is undoubtedly in the last few sentences to do with CPS conduct in court. But the main issue is with the last sentence. If the scope of these immunities did cover the conduct of the relevant actions, should the immunity be granted? Absolutely. Or was an analysis of the justification required for it required before deciding whether to apply the immunity or not? You'll see that the judge uses the same formulation at 21.2, last sentence, when he's framing the questions for himself. Now, in fairness to the judge, this was a creation of the respondent's making, the idea that for some immunities, their application needs to be justified by reference to the facts. We can see that from paragraph 42 of the judgment, which is at the foot of page 156.
Yes.
And then over to 157 at the top. But the immunity needs to be justified to cover the acts complained of. And then the appellant's submissions that the defendants carry the burden of proof to show the public interest justification necessitating the immunity. The justification outweighs the public interest in providing a right to redress for any tortious wrongs suffered on the facts of...
There's no dispute that the appellants carried the burden of proof.
Correct.
Yep.
It's more carries the burden of proof about what.
Exactly.
And so the latter passages in the judgment, of which we are sadly critical, were not all things that the judge thought of himself. They reflected the respondent's submission to her. You can see that again at paragraphs 44 and 40.
Including the word justificationism?
Sorry?
Including the word justificationism?
I can't give my lady an answer to that. I think that is indeed the judge's own creation. I haven't seen justificationism referred to in Miss Murphy's skeleton arguments before Her Honour Judge Brownhill or Mr Justice Ritchie, nor in any notes of the hearing. So I think that is the judge's creation. So 44 and 45, the same submissions in relation to the advocate's immunity and the CPS. The same point arises. The respondent came up with the idea and the judge ran with it. The judge's theme is developed in paragraph 73 of the judgment, which is on page 169. He starts in 73 by analysing Taylor, which we'll come back to all of this in a moment, but just to orientate ourselves, he does that on page 170, 171, and 172. And then at the bottom hole punch at 172, he says this case, that Taylor, confirmed that extending immunity from witness immunity before court to legal proceedings immunity before court, covering not only witnesses, whether called or not, but also investigators, requires an analysis of necessity. The justifications were provided. The immunity was extended, but was less absolute and more qualified than witness immunity at court. It needed to be grounded in justification by reference to the underlying rationale. And here we see the seeds of the error beginning to be sown. And there are two seeds, we say, each related to the other. Firstly, when considering the extension of the immunity in Taylor to the work of investigators, the judge seemed to have thought that post-extension by the House of Lords, the immunity is still a qualified one, and its application requires to be justified on the facts of each particular case. That, with respect to him, is a fundamental error. But once the immunity was so extended by the House of Lords, then if on a particular case the facts fall within the four corners of the immunity as extended, then it's an absolute immunity that falls to be applied, not a qualified one. And secondly, simply because in order for their lordships in Taylor to have extended the boundaries of the immunity, to have considered an examination of the justifications for doing so, that does not mean in every subsequent case the whole process of justificationism must be repeated, as the judge seemed to think was necessary. The judge returns to his theme in paragraph 84, which is on page 184. By this time, when we get to 84, having cited Darker and Hall and Simons, he says that those cases, last sentence, show a movement away from absolutism towards analysing the justification. And with respect to the judge, that's simply wrong-headed. It's one thing to say that when there is a challenge to the existence of a well-established immunity in the House of Lords or the Supreme Court, then the justifications for the maintenance of the existence of the immunity fall to be assessed.
That's your first point
Yes.
made already under...
Yes,
Yeah.
it's quite another, which is what the judge proceeded to do, to require there to be an examination of the facts in every case to determine whether, on balance, the application of the established immunity is justified. The judge applies this principle of justificationism to the police in paragraph 105 of the judgment. You'll see that on page 196. And paragraph 106 on page 196. In particular, the last few sentences of paragraph 106. About 5 lines in, the court is required to look at the function performed, not just at the category of person. We accept that, who has performed it. The court must look at the way that the function was performed and the effects, in particular on witnesses and justice. The court will analyse whether the actions undermined the justifications for the claimed immunity. Then he carries that approach into effect in paragraph 107 in the bottom third of the page, saying by the second hole punch, based on the more recent justification approach of the appellate courts, the better questions which the appellant asserts that the immunity is injustice, where the appellant asserts that the immunity is unjustified or the facts are outside its scope, appear to me to be, and you'll see that he sets out his 4 questions. Does the behaviour in 1B support or undermine the justifications for the claimed immunity? And then under 2, 3 and 4, and then the rubric at the bottom of page 197, if the defendant has passed through these gateways, there's a balancing exercise to be performed. Whether the way the function was performed so undermined the justifications for the claimed immunity that the swings and roundabouts argument should be rejected. And then he applies to that a principle that any immunity ought only to be grudgingly applied. He then applies those in paragraphs 108 to 111 in the case of the police service. He did the same in relation to the Crown Prosecution Service, i.e. his reasoning in principle that it was necessary to find a justification for the application of advocates' immunity at court. That's paragraphs 113 and 114 on page 200. And then in paragraph 115 is the judge's search for a justification on the facts of this case. And we say that this approach for examining the conduct in question and seeing whether it supports the policy reasons that have been identified to justify the application of the immunity was wrong for a range of reasons of basic logic and principle, but also contrary to many hundreds of years of authority. Starting with basic logic and principle, the way the judge approaches matters means that in those cases where the immunity is not needed because the relevant actor has acted properly and in good faith, the immunity exists. But in those cases where the relevant actor has made a mistake or behaved inappropriately, i.e. where there would otherwise be liability, the immunity does not exist. And secondly, by suggesting that the relevant exercise falls to be undertaken by reference to the consequences, the judge permits matters to be brought into account about which the advocate knows nothing. But more than those errors of logic, this approach is contrary to many years of authority. It's firstly inconsistent with the Court of Appeal's foundational decision in Munster and Lamb, which decision has not been doubted, less still overturned, in the last 142 years, and has instead been approved by the House of Lords, I'll give the references in a moment, in Taylor and the SFO, in Hall and Simons, by the Supreme Court in Jones and Caney, and by this court in Sing and Reading Borough Council. Can I start, please, with Munster itself? Authorities, Volume 1, Tab 6.
Yes.
Page 89 in the electronic folders. This was, as is well known, a claim for defamation brought against an advocate in a petty sessional court who had suggested in the course of proceedings that the plaintiff, who happened to be a barrister, had kept drugs at his house. At first instance, Mr. Justice Matthew confirmed the non-suiting of the plaintiff in his defamation proceedings. But he said something of significance, and we'll see that at page 96. By the first hole punch.
The Seaman and Netherclift reference.
I'm so sorry.
The Seaman and Netherclift reference.
Yes. All that was intended to be laid down was this, that for defamatory statements made by an advocate outside of his office of advocate and with no reference to the subject before the court, and which therefore were necessarily made in bad faith and were irrelevant, a counsel might be proceeded against in an action. This seemed to contemplate that there were boundaries or borders to the scope of the advocate's immunity in court. If we see what Lord Brett, Master of the Rolls, held at our page 100, it's right in between the hole punches. For the purpose of my judgment, I shall assume the words complained of were uttered by the solicitor maliciously, that's to say, not with the object of doing something useful towards the defence of his client. I shall assume that the words were uttered without any justification or even excuse, and from the indirect motive of personal ill will or anger towards the prosecutor, arising out of some previously existing cause. And I shall assume that the words were irrelevant to every issue of fact which was contested in the court where they were uttered. Nevertheless, insomuch as the words were uttered with reference to and in the course of the judicial inquiry which was going on, no action will lie against the defendant, however improper his behaviour may have been. I'd said I would give the references to the approval of Munster and Lamb more recently. I'm not going to ask the court to turn them up, but just list them. Firstly, Taylor, Lord Hoffman, Authorities, Volume 1, Tab 13, page 257 at F. Secondly, Lord Hoffman in Hall and Simons, Authorities, Volume 1, Tab 19, page 446, letters E to G. 446.
Thank you.
Lord Hope in Jones and Caney, Authorities, Volume 2, Tab 26, page 513, his paragraph 136. And lastly, Lord Justice Lewison in Singh, Authorities Volume 2, tab 31, page 814, at his paragraph 24. The second reason that the judge's approach of having to reach for a justification for the application of an immunity in every case is wrong is that it's inconsistent with the principle that the immunity cannot be defeated even by proof of malice. Now, there are many cases to which I could point in order to establish that proposition. For now, it's sufficient to refer the court. I don't think there's any need to go there. Taylor, Lord Hoffman, page 257 at F. Lord Hutton, page 270 at D to E. Thirdly, and contrary to the judge's judgment...
And you say that because public policy would never be, as it were, in favour of supporting something said maliciously.
Yes.
Yeah.
Thirdly, and contrary to the judge's judgment below, the principle of absolutism has not been eroded in any way. Instead, it's been repeated and applied in all of the four of the modern House of Lords and Supreme Court authorities, as well as decisions of the High Court and the Court of Appeal. But I'm only going to list House of Lords or Supreme Court decisions where they apply an absolute immunity. Lord Hoffman giving the leading speech in Taylor, page 258E, where he said, I'm not going to ask the court to go in the interest of time to these, the immunity is absolute and cannot be removed by the court or affected by any subsequent publication of the statement. Secondly, Lord Hutton in Darker, page 345 at D to E.
345.
345 D to E. In order to shield honest witnesses from the vexation of having to defend actions against them and to rebut an allegation that they were actuated by malice, the courts have decided that it's necessary to grant an absolute immunity to witnesses in respect of their words in court, even though this means the shield covers the malicious and dishonest witness as well as the honest one. Lord Hoffman in Hall and Simons, page 453 at B to C. A witness is absolutely immune from liability for anything which he says in court. So is the judge, counsel, and the parties. They cannot be sued in libel, malicious falsehood, or conspiring to give false evidence. This policy is regarded as so important that it requires not merely qualified privilege, but an absolute immunity. And lastly, Lord Phillips in Jones and Caney, at page 682, paragraph 13. The barrister is, however, still protected by an absolute privilege from a claim in defamation relating to statements made in the course of the conduct of legal proceedings. So although in each case the court was engaged in a line-drawing exercise, after it had drawn the lines, the immunity was absolute. Fourthly, the judge's approach is contrary to one of the central reasons for this immunity being an absolute one, namely that a foreseeable immunity promotes certainty, which enables participants in the legal proceedings to speak freely and without fear that their words or conduct will be later called into question in satellite proceedings. See in particular Lord Hoffman in Taylor, page 264 E to G. The policy of the immunity is to enable people to speak freely without fear of being sued, whether successfully or not. If this object is to be achieved, the person in question must know at the time he speaks whether or not the immunity will attach. If it depends on the contingencies of whether he will be called as a witness, the value of the immunity is destroyed. So for all of those reasons of logic and principle, and by reference to the authorities that I have mentioned to the court, the judge ought never to have engaged in an exercise in which he undertook an evaluative judgment about whether or not imposing liability would or would not improve the CPS's advocacy, would or would not make them think more carefully before they disclosed any information in court, and would or would not prevent the occurrence of muck-ups. I'm not going to address, and instead leave it for others, the effect of the judge's approach that it might have on the core basis for the advocate's immunity. I'll leave it to others, i.e. the need for prospective certainty for an advocate as to whether his or her words are covered or not, nor upon the serious risk that, in the light of the judge's judgment, the uncertain scope of the immunity may have on advocacy in court proceedings. I take the simpler approach now. What the judge did was fundamentally wrong in logic and principle and contrary to authority. And so, for those reasons, the appeal should be allowed on our ground too, and the claim struck out insofar as it relates to the Hampshire disclosure. I'm about to turn to our ground 3, and immunity insofar as it applies to police conduct. That might be a convenient moment.
Yes, it would. Great. Thank you. 10 minutes. Thank you very much.
Totally exciting.
She's at least 5 or 6 cabinet ministers she's put down. Sam Allen already down. And she did the same story, which got me.
Yes, Mr. Bell.
Thank you, Lady. Can I turn to our ground 3, the
Yes.
Established extension of the advocate's immunity and the witness immunity to the conduct of the police in question here? Our primary position is that if ground 2 succeeds, then the claim for damages by the respondent, there being no claim for a declaration, crystallised only on the disclosure by the CPS advocate in court. That was the correct conclusion of the judge at paragraph 112 of his judgment, and the respondent doesn't seek to displace it, as I've said. Our secondary position is...
But in the light of our exchange earlier, Mr. Beard, do you maintain that?
Yes.
You do? I mean, how does that work?
The
immunity attaches to the conduct, we agree on that. So why does it matter if the harm caused by any misconduct or error on the part of the police?
There's no pleaded claim arising solely from the disclosure by the police to the CPS.
We're looking at immunity. We're not talking at the completion of the cause of action or anything.
Yeah,
When the damage occurred, we're looking at immunity.
but we're looking at the striking out of a claim or a cause of action. And if, as the judge in the lower court found, Her Honour Judge Brownhill found, and as Mr. Justice Ritchie found, that the cause of action couldn't be complete, that the causes of action couldn't be complete until damage was caused, then I maintain the point.
But we know that you, with respect, rightly agreed that immunity doesn't attach to harm. So we're just looking at immunity.
Yes.
So we're just looking at the police actions. The fact that the harm occurred as the result of the actions of somebody or something that was done in court is nothing to the point when we look at the immunity for the police.
The immunity of the police, I agree.
Right.
Which is what I'm turning to
And that's
now
what
in
we're
my
looking at
ground three.
two. Okay.
So our secondary position is that the provision by the Chief Constable's officers or staff of the case file to the CPS, and within it a contact details sheet disclosing the name and contact details of XGY, fell within an established extension of the advocate's immunity and or witness immunity. Now, it may have got lost amongst the many authorities that we have collectively treated you to, but of foundational importance to our case is the decision of the House of Lords in Taylor and the SFO. And I'd like to spend a little time on that, if I may. Its authorities, Volume 1, tab 13, page 227.
This is the SFO
It
investigation.
is. It is.
Yes.
So if we're at 227, just to get back into the facts back in 1997, 1998, could I invite you to read the head note down to letter G, please, on page 227?
Yes, I remember this.
Thank you. Now, there were two issues, therefore, before their lordships, and the House of Lords has split in the way that it determines the appeal. On the issue that we're most interested in, the immunity, the majority, that's Lords Gough, Hoffman, Hope and Hutton, held that the immunity from suit, which applies to judges, advocates and witnesses in respect of statements made in court, extended to out-of-court statements, which could fairly be said to be part of the process of investigating a crime or possible crime with a view to prosecution. All 5 members of the committee held that an implied undertaking arose in the criminal proceedings.
Did not.
That's not an issue. No. So having worked out that the majority of 4, can we see how the speech is divided up before looking at Lord Hoffman's leading speech? So Lord Hoffman gave the leading speech. That's at page 255A. And then if you go to 257F, that's where he begins his introduction of the immunity principle, having dealt with implied undertaking. And then if you go to 258B, where he formulates the issue, having cited Watson and McEwen, right next to B, the question in this case is whether the immunity extends more generally to statements made to or by investigators for the purposes of a criminal investigation. We're going to come back in a moment to what he held. At the moment, I'm just identifying their lordship's decisions. 254H.
Going backwards.
Yes, Lord Gough agreed with Lord Hoffman.
I see. Yes.
270 at C.
Sorry, Lord Lloyd. No, Lord, I think that's Lord Lloyd.
I'm so sorry. No, at H, it's Lord Gough.
Yes, starting, but the I'm in complete agreement is Lord Lloyd. He was in the minority, Lord Lloyd, was he?
Yes.
Right.
Yeah.
I mean,
So I'm dealing with the
you're
four.
just taking us to the bottom of 254 where he says, I agree with Lord
Oh,
Hoffman.
yeah, exactly.
Okay.
Thank you, my fault. Thank you.
Lord Hope, 270 at C. He agreed with Lords Hoffman and Hope, albeit he gave a speech on the other issue in the appeal, the implied undertaking issue, against the collateral use of material. 270 at D, Lord Hutton, adding some more reasoning of his own on the immunity of principle. And then, as my lady has said, Lord dissented on the issue at 253D to G. And so we've got a strong majority of the House of Lords agreeing with Lord Hoffman, with Lord Hutton delivering some supplemental reasoning. Can we go, therefore, back to how Lord Hoffman determined the appeal, 263 at H. Can I invite the court, I'm sorry about this, to read 263 at H right through to 265 at B?
Certainly. So if we're looking at page 264,
Yes.
Lord Hoffman is looking at persons assisting the police with their inquiries, investigators,
Yes. The passage
being
which
able to exchange theories and hypotheses.
Yes, so the passage, the important passage, but in deference to his reasoning, I've asked you to read the run-up to it, is the paragraph beginning just above H, when one turns to. And the really important part is, in my view, it's necessary for the administration of justice that investigators should be able to exchange information, etc. That's the critical part of the ratio. And then over the page, equally as significant, he agrees with the test proposed by Mr. Justice Drake in Evans. The protection exists only where the statement or conduct is such that it can be fairly be said to be part of the process of investigating a crime or possible crime with a view to a prosecution or a possible prosecution in respect of the matter being investigated. And that formulation excludes statements which are wholly extraneous to the investigation, irrelevant and gratuitous libels, but applies equally to statements made by persons assisting the inquiry to investigators and by investigators to those persons or to each other.
And what do you say the police's actions were here?
They were making a statement in a form that they are required to provide to the CPS as to the address of a witness in the case. It's a fortiori to this antecedent stage of the process, which is talking about investigators exchanging information with, as we'll see in a moment, other investigators or people who might be able to give information when there are no criminal proceedings, you see that the court has introduced the qualification that it must be in relation to proceedings or possible criminal proceedings. We are in a much stronger position than that. We are in a case where there were criminal proceedings and we provided the relevant information in the course of extant criminal proceedings. And it wasn't an exchange with, in this case, it was a law society lawyer and their views about an individual. This was an exchange with the prosecutor for the purposes of the conduct of criminal proceedings. We're stronger on every front, more closely or more within the immunity than identified by Lord Hoffman. Can I see how the respondent deals with this?
Before you go there,
Yes,
just looking at the words irrelevant and gratuitous,
yes.
could be said that were the opposite side of the coin for defining what falls within the immunity. If you were looking at the words relevant and connected to, and the other side of the line.
Yes, it's the obverse of what my
Obverse.
lady identified earlier in relation to absolute privilege and how that is approached in relation to in-court advocacy and witnesses giving evidence. I had actually meant to highlight that when I said earlier I was going to show my lady a passage that related to the point that you took, and that was indeed it. Can I see how Miss Murphy deals with Taylor? This is the only part of her skeleton that I'm intending to go to, leaving open Taylor.
Okay.
But it's Core Bundle 1, tab 8, page 117.
Sorry, paragraph?
40. The Chief Constable's defence of Her Honour Judge Brownhill's conclusion that the Hampshire disclosure fell within the extension of the witness immunity to out-of-court statements is based in part on a misunderstanding as to the reason why in Taylor a file note was found to fall within the scope of witness immunity. So in her first sentence, she refers to the document, singular, in issue in Taylor as being a file note. As the court will have seen, in fact, there were two documents in issue which were said to contain defamatory statements and upon which the claim was founded. If you just turn up 255 between letters B and C in Taylor. .255 in the speech of Lord Hoffman between B and C just between B and C by a letter dated the 4th of May. The lawyer employed by the SFO made a formal request to the Attorney General of the Isle of Man asking for his assistance. At F, Miss Mackenzie's letter presented the facts as they appeared to the SFO, depicting essentially Mr. Taylor as being guilty of suspicious activity. And then you'll see the second document is the file note, 255 at H, separate incident. Miss Mackenzie and a colleague called upon Mr. Rogerson, who worked for the Law Society in the administration of the Solicitors' Compensation Fund, to talk about the transaction. She made a file note of the interview, recording Mr. Rogerson's view that over the page, Mr. Taylor should be struck off as a solicitor, and her own contention that Mr. Taylor was a co-conspirator. So the first point to make is that the respondent's suggestion that Taylor was about a file note is incorrect in that it's an incomplete description of the documents in issue. That's not me picking hairs. It's important in the light of the points which the respondent then seeks to build upon the case being about a file note alone. Back to Ms. Murphy's document. Her second sentence, the file note in question recorded a view by an investigator to a person helping with the inquiry. It related to the evidence, word underlined. Again, that second sentence is restricted to the file note and impliedly suggests that the reason why immunity was held by the House of Lords to apply to its contents is that it related to the evidence, hence the underlining. Now, the cross-reference in Miss Murphy's document at footnote 28 is to part of Lord Hoffman's leading speech, which is on page 263 of our authorities, if we turn that up. This is the passage that we've read already. You'll see that 263 at H starts with the introduction of the issue, saying that the immunity claimed was a novel one, but as we will have seen, it's a novel claim upheld by their Lordship's House. And then we'll see what Lord Hoffman deals with in between. That introduction and the ratio that I've drawn your attention to. He deals first with the letter, one investigator to the other. That was not said to be evidence or likely to be evidence, quite obviously. A letter from an SFO lawyer to the Attorney General of the Isle of Man. He then next deals with the file note, what the investigator said to the Law Society gentleman. And again, that was not said to be evidence or likely to be evidence. We then get to the statements made by the Law Society gentleman to the SFO investigator. And then Lord Hoffman said that that person was, quote, not intended to be called as a witness. So far from his lordship explaining that the application of the immunity was justified because it contained evidence contained in a document which was likely to become evidence or somehow related to the evidence, his lordship said no such thing, indeed quite the opposite, making the point that what the person said to the investigator, they were not intended to be called as a witness. Third sentence of Miss Murphy's paragraph 40, there was a foreseeable possibility that the note would be used in evidence, even if its author was not called to give evidence. That footnote 29 takes us to page 260 of Lord Hoffman. The first point is, again, the respondent is restricting herself to the file note and ignoring the letter. But even if we chase down her footnote 29 to Lord Hoffman at 260 D, which is the reference that she gives, you'll see between the hole punches, it says, in the case of information which has not been made public, like the letter and the file note in the case, the fact that publication may have been foreseeable as a possibility at the time when the documents were written does not mean that privacy and confidentiality should not be preserved so far as it is possible to do so. Equally possible that documents disclosed in civil discovery will be published in court. That does not mean there's no point in the court retaining control over them. That's dealing with the separate point, the separate ground of appeal concerning the implied undertaking, and with respect is nothing to do with the court's reasoning for holding that the immunity applied to the passage of the information contained in the letter and the passage of information contained in the file note. But worse than that, it doesn't actually say what the respondent says it does, i.e. that there was a foreseeable possibility that it would be published through use in open court proceedings, and that was a relevant factor in the application of the immunity. In short, it's wrong to lift a sentence concerning the other part of the case, misstate it, and then apply it as if it was part of the court's reasoning for the application of the immunity and an essential step in the court's reasoning on the immunity. the respondents focus on the importance of the likely status of the document, the file note or the letter, as a piece of evidence that would be used at trial, like a witness statement, is also entirely inconsistent with how Lord Hoffman decided the case. You can see that at 264E. Approaching the matter on this basis, I find it impossible to identify any rational principle which would confine the immunity for out-of-court statements to persons who are subsequently called as witnesses. And then the respondent's fourth sentence in paragraph 40, last word on the page, Lord Hoffman explained that, and then there's a quote, the proper administration of justice requires that such persons, etc., and that the same degree of protection should apply to statements shared among investigators about the investigation. There's a cross-reference in footnote 31, which takes us to Lord Hoffman at 214 G to H, which is our 264 G to H, which we've read a number of times already. Here he's turning to the position of investigators, people like my client. And what Lord Hoffman describes at 264H is exactly what we did here. We passed information given to us by XGY, her address, to a colleague in the CPS. The respondent continues in the fifth sentence on page 118. By contrast, the contact card in the present case was, to use Lord Hoffman's phrase, wholly extraneous to the bail hearing, in that it was never contemplated or intended by the Chief Constable that it would become evidence. With respect, what the respondent's doing here is misappropriating Lord Hoffman's description of what is extraneous, irrelevant and gratuitous libels that have nothing to do with the investigation, and created for herself a new description. Extraneous now means information was not necessary for the purposes of the proceedings in which it was in fact disclosed. And she adds a requirement that it needed to have been contemplated by the Chief Constable that the address would become evidence. For all of those reasons, the court should simply apply, and Mr. Justice Ritchie should have applied, that passage in Taylor, which was drawn to his attention by both Mr. Goss and Mr. Talalay, which he cited in his judgment and which he never distinguished. In this regard, we would ask the court to have notice of the nature of bail proceedings, which do not generally involve the giving of evidence. That is the procedure, i.e. justices may come to conclusions in bail proceedings on matters that are not strictly admissible, is probably known by the court in any event, but if it was necessary, it's established by the Havering Magistrates Court case. I don't know whether the court's had an opportunity to see that already, but if we take a quick look at it, please. Volume 1, page 367. Tab 18.
Yes. Yes.
And it's paragraphs 39 to 41. In fact, the facts don't matter. I think it was one of those cases about criminal causal matter and the route of appeal. 39 to 41 on pages 367 and 68.
And what is the short point?
The short point is that in bail proceedings, the process is that information may be put before the court which is not strictly evidence that would be admissible at a trial.
And that's paragraph 41 in particular, I
Yes.
think.
That if it comes to a breach of bail, it may be necessary for what was otherwise information passed on by an advocate to be translated into evidence, depending on the circumstances and the justice considering the bail breach.
Because it may result in a charge,
Yes,
simply.
it may do. But what this means is that it cannot be foreseen what information provided by the police to the CPS in the file generally, but more specifically for the purposes of a bail hearing, will be challenged and which will not. What will be relevant or not to the bail hearing, and which may need to be translated into evidence. But we say the judge should have approached the issue with respect to him by recognising that all of the information provided by the investigator to the advocate for the purposes of the criminal proceedings for use at the bail hearing, which must include the victim's detail, could potentially be deployed in the course of the bail hearing, whether as evidence or not. Taylor is a case which in this context shouldn't be consigned to the bin of ancient history. It was applied by the House of Lords in Darker. I'm going to give you the references to that without taking the court to them. The head note itself, page 316, where the ICLR state that Darker was applied. Taylor was applied in Darker. That's made good by Lord Hope's speech at page 328G. Perhaps not surprising because he gave one of the leading speeches in Taylor too. Lord Mackay at page 331E to G. Lord Cook at 335C to D. And Lord Hutton at 347A to F. It was also quite recently, or recently in the context of the antiquity of this immunity, applied and approved by this court in CLG and the Chief Constable of Merseyside Police. If we can look at that briefly, please. Authorities, Volume 2, tab 35, page 905.
Yes.
And 905 is the beginning of the report. The court can see the facts from paragraphs 3, 4 and 5 on page 906. And so there were 2 points that Mr. Johnson for the Chief Constable was arguing, both of which succeeded. The first was a duty of care point, whether the police service owed in those circumstances, CLG and AGD, any relevant duty of care at common law. But an alternative plank of his argument was immunity. And we pick that up at page 913, paragraph 25. This is part of the judgment of the then Vice-Chancellor, Lord Justice Morbick, with whom Lord Justices Fulford and Voss agreed. That's where the discussion of witness immunity begins. And the passage that I would draw to the court's attention is on 916 at paragraph 32.
Yes.
One of the features of the present case is that the claim is based not on anything that TC Gaffney said in his statement, but what the police and the CPS subsequently did with it. It's accepted the police, the CPS should have been alerted to the fact that the statement contained sensitive information and that on this occasion the system for ensuring that it was examined by the disclosure officer broke down. I interposed to say, you'll note the similarities with our own case. The question for decision, however, is whether the transmission of the statement by the police to the CPS was part and parcel of preparing DC Gaffney to give evidence. In my view, it was, because it falls squarely within Lord Hoffman's statement in Taylor. It's true that the action in the present case is not based on the nature of the statement itself, as it would be if the claim was for defamation. It's based on the transmission by the police to the CPS of a statement required for the purpose of enabling Gaffney to give evidence in court, as he subsequently did. In substance, the position is essentially the same as if Gaffney had made his statement orally to a representative of the CPS. To hold the police liable for communicating its contents to the CPS would outflank the immunity to which they were entitled in relation to the evidence once given in
You may
court.
be about to get there, but how did the learned judge below deal with this authority?
He said that it could be distinguished on the ground that DC Gaffney had provided a witness statement,
Yeah, so it was the evidence argument.
MG11, and therefore it was evidential, and that things that were not evidential didn't fall within the immunity. I'm summarising.
So back to your first point of limiting the immunity before you got on to justification.
In relation to the passage in substance, the position is essentially the same as if Gaffney had made the statement orally to a representative of the CPS. But we say this makes it clear that the application of the immunity didn't depend on the method of communication from the officer to the CPS. It didn't depend on the communication being in a witness statement. Lord Justice Morbick says, in substance, the position is the same as if Gaffney had made his statement orally to a representative of the CPS. It didn't depend on the fact, in that case, the information happened to have been conveyed in a witness statement. The immunity could equally have been applied if it had been passed in a conversation, or here, in our case, in a much more formal way, as required by the instruments that govern the provision of information from the police to the CPS, to which I'll turn in a moment. As I said, despite the judge having this important passage drawn to his attention by Mr. Talalay for the Chief Constable and Mr. Goss for the CPS, he cited it to the judge in his paragraph 73.
Right, 73 is the way he deals with it. Thank you.
The important passage in Taylor is the one I was referring
Oh, I
to.
see, okay.
He then fails to deal with it. Instead, he took 3 points so far as the Chief Constable is concerned. His justificationism point, the provision of, secondly, the provision of the address to the CPS was extraneous to trial. And thirdly, the act of providing the appellant's details, including the CPS, was, quote, an administrative act and not an evidential one. So this is how the judge...
I'm very sorry, Mr. Beer. What was your first of those three?
First was his justificationism point.
Oh, right.
I'm going to deal with each of these three.
I thought you were, but I like a heading.
Yes. Heading 1, justificationism. Heading 2, provision of address to CPS was extraneous to bail application because it wasn't evidence. 3, it was an administrative act. Can I deal with those in turn? Justificationism.
And could you just remind me where, could somebody give me the paragraph reference in the judgment below where the CLG case was addressed? I just
Yes.
can't find it. Can you? Paragraph 95 and 96, 97.
Yes.
So the central point is that the address, he says, paragraph 98, the address was crucial evidence for the arrest warrant in
Yeah,
CLG.
that was the answer that I gave to my lady
It was.
3 or 4 minutes ago.
Thank you. So paragraph 95.
It's
to- yeah,
98, culminating in 98.
Thank you.
So dealing with the three...
Dealing with Taylor.
I'm
Back
sorry.
to dealing with Taylor now.
Yes. So looking firstly at the judge's reasoning for seeking to sidestep the application of Taylor, it's justificationism. And this is judgment, paragraph 109, page 198. So against his heading, did the scope of the immunities cover the actions of the police, and should immunity be granted? In paragraph 109, he says that we're dealing with an extension in immunity, and that the case law over the page demonstrates that it springs from the need to protect witnesses and the evidence given at trial. The rationale for the immunity in the case was to protect the appellant from being in danger from DYP, so she could give evidence at trial as a witness against him and thereby further the aims of the administration of justice. Public policy is in the proper administration of justice entail protecting her and not endangering her. The judge appears to be saying that even if we're in an immunity as described, it's necessary to conduct a balancing exercise. I've already addressed the error in that approach in my general submissions relating to ground 2, but specifically in relation to what the judge held in his paragraph 109, he fell into precisely the same errors he did in relation to the CPS. There are some additional reasoning or features of the errant reasoning too. Page 199, the second sentence. The whole rationale for the immunity in this case was to protect the appellant from being in danger from DYP. It's entirely unclear with respect to him where the judge got that from. No one was suggesting that the rationale for the police having immunity was to protect XGY from attack by DYP. And then a little further on, the public policy and the proper administration of justice entail protecting the appellant, not endangering her. This makes the same mistake with respect to the judge as before, in that it means the immunity only exists for those who do not need it, i.e. those who don't make mistakes. The judge's second reason, the police conduct was extraneous because the provision of XGY's address had nothing to do with the provision of evidence by XGY at trial. And that's back at paragraph 108, with the sentence next to the first hole punch. The work done by the police employee was found by the judge to be in accordance with their duties to provide the witness contact address to the CPS. But in my judgment, that had nothing to do with the provision of evidence by the appellant, that's XGY, for the criminal cases being investigated. One might add a side note here, that's consistent with his earlier conclusion at paragraph 79. Because the provision of the address was not part of the evidence to be given at a trial, the bail hearing itself was extraneous for the purposes of the immunity. Add another side note, his paragraph 80. I accept that it was arguable that her confidential address was not evidence in the rape case. It proved nothing of the crime and was irrelevant to the bail hearing, and it was extraneous, he said in his paragraph 80. So you can see the seeds of that sentence on page 198 by the first hole punch, back in paragraph 79 and 80. And I would simply ask the court to think back to how Lord Hoffman described in Taylor what was outside the scope of the immunity, where the conduct in question was such that it couldn't fairly be described as being part of the process of investigating a crime with a view to possible prosecution. A formulation, he said, which excludes statements and information which are wholly extraneous to the investigation, namely irrelevant and gratuitous libels. Well, how far have we come on the judge's ruling? It's not clear how the judge translated that into a requirement that the conduct in question needed to be about the provision of evidence by XGY at a trial. That limitation or restriction imposed by the judge upon himself, that the relevant conduct must have occurred at a trial or for the purposes of a trial, and the giving of evidence at the same, is without support in any of the authorities. The authorities all refer to the immunities applying in the ordinary course of proceedings in a court of justice or in the course of judicial proceedings. I'm going to give you the cross-references to those, but in the interest of time, I'm not going to call them up. Chief Baron Kelly in Dawkins and Rokeby.
Sorry, I was just thinking about something else. Could you give me these are references for
These
what?
are references to the immunity applying in the ordinary course of proceedings or the ordinary course of judicial proceedings, not limiting them to evidence being given by somebody at a trial. So Chief Baron Kelly in Dawkins and Lord Rokeby, which is Authorities Volume 1, page 78, second paragraph from the bottom. And Lord Justice Sellers in Marinan and Vibert, Authorities Volume 1, page 128, again, second paragraph from the bottom. But proceedings under the Bail Act 1976, including granting or bail without or with conditions, and the refusal of bail, are important parts of the criminal process. If authority was needed for that obvious proposition, it's found in the Blandford Justices ex parte Pament case, see Volume 1 of Authorities, page 144 and 148 at G. The then Master of the Rolls agreeing with Lord Justice Taylor, there can be no possible ground for describing an order granting or refusing bail as collateral to criminal proceedings. The grant or refusal of bail to a defendant in criminal proceedings is an integral part of the process. It's very obvious. This court itself has treated proceedings for bail as falling within an immunity from suit when it was suggested that police officers had improperly objected to bail by providing the CPS advocate with false or unreliable information. That is the important case of Gizonio, to which I will turn. Authorities, Volume 1, tab 11, page 151.
Yes.
Thank you. The facts were that two men had pleaded guilty to committing a series of criminal offences, but brought a civil claim for damages in relation to three matters, and we can see those at the foot of page 151 and over to 152, numbered
I see
one.
Miss Barton was in this case as well.
She was. That's not the only reason I'm citing it. And she was successful. That is the reason I'm citing it. We'll see numbered 1, 2, and 3, bottom of 151 and on to 152. The issues in the causes of action pursued by the claimants. And it's number 3 that's really important. So it was a claim for misfeasance against police officers in respect of objections they put forward to courts when the courts were deciding on bail, i.e. information that the police officers had conveyed to the CPS orally and in writing, which was used by the CPS in the course of a bail hearing. And we can see at page 153 what was alleged in paragraphs 19 and 20 of the Statement of Claim. Can I just invite you to read that? 153, the allegations on malicious objection to bail. Now, Lord Justice Henry gave the only judgment, with Lord Justice Aldous and Sir Christopher Staunton agreeing with him. The interesting part of it is his treatment of an argument by counsel for the appellants, Mr. Howard, that bail decisions could be isolated from other parts of the criminal process. And we can see that at 159. About halfway or two-thirds of the way through the first paragraph, it would be quite wrong to ignore those inconveniences and artificially isolate bail decisions from all of the other decisions in the investigation and prosecution of the defence in order to bring a civil claim based on misfeasance in public office. Accordingly, I'm satisfied the immunity rule here applies because the bail decisions were part of the process of investigation of crime with a view to prosecution. And then 160, penultimate paragraph, those investigating, preparing, or testifying in the trial process. So note the three possible ways in which the court describes matters, who act maliciously to pervert the course of justice are liable in the criminal courts. But there's a strong public interest in protecting from civil suit the vast majority of those who bona fide are part of the investigatory, preparatory or evidential process, three ways again of describing matters, in successful prosecutions. Issues in such prosecutions should not be relitigated in the civil courts. Here, all matters relating to bail were part of the investigatory or preparatory process in criminal proceedings. Absolute immunity, therefore, applies.
I know the use of the word successful, but I think that on my reading of this authority, that relates to the unusual facts of this particular case.
Yes,
They're
I
quite
think that
striking.
feeds into his last conclusion, if you look. It would be bizarre indeed if these plaintiffs could recover damages. So there was a certain distaste in his lordship's mouth. But that's not a necessary part of the formulation. In fact, in this case as well, there was a successful prosecution. You will have seen that DYP was successfully prosecuted for 6 counts of assault. But that's not a necessary part of the court's reasoning, either here or there. But it's interesting to compare the judge's approach to how he might have considered the same issues had the disclosure occurred perhaps in the course of civil proceedings. Does the advocate's immunity of court only apply to trials and not to interlocutory proceedings? If so, why? What is the principal justification for this new limitation found in any of the authorities? What if this address had been provided by the police to a solicitor applying for a stalking protection order or a sexual harm prevention order, or indeed one of the range of the dozen or so other protective measures heard by the magistrates' court exercising its civil jurisdiction? His third reason, the police conduct was an administrative act, not an evidential one. His first point is the Hampshire address was not evidence. But we say with respect that's entirely the wrong question to have asked and answered, focusing on whether the communication from the police to the CPS was itself evidence or related to the evidence. Again, I would ask the court to think back to the documents in question in Taylor, a letter seeking assistance with interviewing a person under suspicion, a note of a file note of a conversation with a regulator. Neither of those was evidence nor likely to become evidence, as we've seen. They ended up being disclosed in the unused material. And in any event, our communication, required to be given by statutory guidance for the purposes of the conduct of the proceedings, is in a much stronger class of case. I should just deal with the judge's marginalisation of the documents that the advocates put before him on behalf of the then respondents, showing that it was required of the police service to provide contact details of witnesses to the CPS. They are the Director's Guidance on Charging, 5th edition, May 2013. That's Authorities, Volume 5, tab 59, page 2037.
Page.
2037.
So this was in place in 2020, was it?
Well, there's one edition in May 2013. There's a supplementary national file standards issued in May 2015 as an appendix to this. And then there's a subsequent 6th edition, which comes later. So I'm going to show you 2013, 2015, and then 2020.
Thank you.
So this is part of the Director's guidance on charging. I should have showed you the beginning part of it at 2027. You'll see by the first whole bunch, guidance to police officers and Crown prosecutors issued by the DPP under Section 37 large A of PACE. So it's statutory guidance. And then at 2037, at paragraph 32, information required for prosecution, the national file standard. So this is the incorporation of the national file standard into the Director General's guidance. And then if we look at what the national file standard was, page 2044, which is a landscape document, you'll see that the relevant box is box 3 from the left under anticipated not guilty plea. And what it must include, amongst other things, is an MG9 list of witnesses. That's the document that has names, addresses, phone numbers, and email addresses of the witnesses on it. And I'll give you the reference to the updated 2020 position without turning to it in the 6th edition of the DG's guidance. That's page 2046. Then paragraph 9.3 on 2070. And then the same form, 2087.
Sorry, 2046 is the first page, then 2070.
2070, which is the relevant incorporation of the national file standards. And then 2087, which is the similar document, but for 2020. And you'll see that it's become slightly more complicated. GAP is guilty anticipated plea. NGAP is not guilty anticipated plea. And you will see
MG9.
MG9, 4th and 5th columns to the right. MG9 must be included. Now, the judge dismissed those documents in his paragraph 110 as documenting administrative procedures. But they're much more than that. They show the information that the police must, by statutory guidance, provide to the CPS for the purposes of presentation of a case in court. And in the last point that I'll make now, before passing to Miss Wolfe, we do ask the court to have regard to the special position of the police service in the application of this immunity. It is, we say, sui generis. It's not a party to the proceedings. The proceedings are brought in the name of the Crown. It's not an advocate. The CPS does that. But it effectively acts as a client who provides information to the advocate for the purposes of court proceedings. The court will have appreciated that many of the cases describe the immunities as applying to the parties, their advocates, and to witnesses. In the context of a public prosecution by the CPS, the police service occupies a number of those roles, although it doesn't fit neatly into any of them. We say in those circumstances it's particularly important in criminal proceedings where the investigative and prosecutorial bodies are different, that the protections which would otherwise apply to a party on the one hand or their advocate on the other also extend to the police service in carrying out their public functions in supporting the CPS in the middle. Lady, those are my submissions on grounds 1, 2 and 3. I've not addressed you on ground 4, which is the exercise of the strikeout jurisdiction. And that's because if you're not with us on grounds 1, 2 and 3, ground 4 doesn't add anything. Can I pass to Ms. Wolf,
Mr.
please,
Bear,
on
you've
ground
been,
5?
Exceptionally clear and helpful. Thank you very much indeed. Thank you very much indeed. Yes, Ms. Wolf.
My ladies and my lord, ground 5 is the challenge to Mr Justice Ritchie's decision to overturn Her Honour Judge Brownhill in granting the appellant's applications for summary judgment in respect of the Hampshire disclosure. She had decided, on the basis that as of the 16th of April 2020, the respondent was not at a real and immediate risk of death or torture, inhuman or degrading treatment, and therefore she found XGY was not a victim for the purposes of Section 7 of the Human Rights Act. I'm going to take you first to Her Honour Judge Brownhill's decision and then turn to that of Mr Justice Ritchie. So I'd invite you to have core bundles 1 and 2 to hand, and towards the end I'll take you to one page of the supplementary bundle. My lady will be relieved that we won't be turning up any of the pages in the authorities bundle. I hope that I will give you some references to it as we go through.
Thank you.
For your note, ground 5 is set out in the Chief Constable's grounds of appeal, which is at tab 1 of the core bundle, page 16, and is also covered from paragraph 15 of our skeleton argument at tab 3 of the same bundle, page 53. In summary, we say that Mr Justice Ritchie erred because, among other shortcomings, he reconsidered the matter for himself, thereby applying the wrong legal test, and he speculated about further evidence that might turn up in support of XGY's position. Turning to Her Honour Judge Brownhill's judgment, it's at tab 19 of the second core bundle, and we'll pick it up from paragraph 42 on page 309. There the judge begins by
Sorry,
setting out...
I've got tab 19. Just give me the
Give me
page.
tab 19, page 305,
Thank you very much.
and it's paragraph 42 on it.
Yeah.
Her Honour Judge Brownhill begins there by setting out the very well-trodden legal test for summary judgment, beginning with the CPR, and then the easy air principles at paragraph 43, which I suspect will be well known to this court. They've been cited in this court on more than one occasion. And I shall just fly through some of those key principles where they are applicable here. Small Roman numeral 1 and 2 show that realistic does not mean fanciful, it means more than merely arguable. Roman numeral 4 says that the court does not have to take at face value, without analysis, everything a claimant says in his statements before the court. That's distinct from taking a case at its highest, of course. And numeral 5, the court could take into account evidence that can reasonably be expected to be available at trial. And then over the page, 2 points that come from numeral 7, halfway down that first quoted paragraph. If it is possible to show by evidence that although material that would put the documents in another light is not currently before the court, such material is likely to exist and can be expected to be available at trial, then it would be wrong to give summary judgment. But, it goes on, it is not enough to argue the case should be allowed to go to trial because something may turn up which would have a bearing on the question of construction. And she goes on to look at the burden of proof, which isn't in dispute. That's a summary of the law which was endorsed by Mr. Justice Ritchie at paragraph 19 of his judgment, just for your note. That's at tab 13, page 147 of the first full bundle. And it was the test which Her Honour Judge Brownhill applied. Staying on page 306 of her judgment, you can see at the bottom of the page she deals with the lack of disclosure point, paragraph 45. She says that the claimant has not filed any evidence in response to the defendant's applications. Over the page, she says that there has been, at paragraph 47, no application for specific disclosure nor for any pre-action disclosure. And towards the end of paragraph 47, she says that she's not persuaded that given the issues the court was tasked with deciding in relation to the Hampshire disclosure, that further disclosure would materially impact upon the pleaded facts. We then come to her analysis, which is at paragraph 105 on page 325. By this point, she has decided to strike out the Hampshire claims.
Yes. So paragraph 105.
You can see there that she's deciding the summary judgment issue in the event that she is wrong about the strikeout claim. Over the page at 107, she sets out the real and immediate risk test for Articles 2 and 3. She goes on to look at some authorities. She considers the parties' submissions over the page from paragraph 114, and then we come to her decision at paragraph 109 on page 328.
119.
119,
Yes.
page 328. She says there that even taking the pleaded points at their highest, I have formed the clear view that the claimant has no real prospect of success, that's the wording of the test itself, in establishing at the time of the Hampshire disclosure that Section 7 victim test, either in relation to Article 2 or 3 of the European Convention. And she goes on to give some facts upon which she relies. By April 2020, the respondent did not allege any contact, whether direct or indirect, from DYP after the end of their relationship on the 6th of November 2019. That, of course, means that there was no contact after DYP learnt of the multiple assault allegations against him and after the Epsom disclosure. The respondent had various dealings with the police before April 2020 when she could have made such allegations. And the judge mentioned the April rape allegation, saying it undoubtedly would have brought the claimant to the fore of DYP's mind again. She finds that those facts do not come close to suggesting, objectively, that the rape allegation created a real and immediate risk. Paragraph 120, she says that the risk that took place in November had dissipated below the real and immediate threshold, and the Hampshire disclosure did not resurrect or create an objective risk near that threshold. At paragraph 121, the last line of that page, she refers correctly to Article 3 requiring an immediate risk on the scale of actual bodily harm. And over the page, at the top, she touches on the claimant's subjective fear, saying she understands that subjective fear. But she's not satisfied that there's a realistic prospect, again the wording of the test, of establishing such a real and immediate risk objectively at the time of the Hampshire disclosure. Paragraph 122, she says that there should be reverse summary judgment in any event. It would be remiss of me not to observe at that point, she doesn't mention the other compelling reason limb of the test, but in my submission, that omission doesn't play any part of the respondent's appeal, and rightly so, because it's implicit in her conclusion that she has found no such reason. At paragraph 123, she deals with the Article 8 claims, and she reaches the conclusion that if you cannot reach the threshold for Articles 2 and 3, then Article 8 adds nothing. And she correctly cites the authority of CLG, which my learned friend has already taken the court to, and which has very similar facts to those in this situation. While we're on this page, it's worth looking too at the Epsom disclosure. Now, of course, the Epsom disclosure was not part of the summary judgment application that we are dealing with now and was allowed to proceed to trial. But the reason that it's relevant is because she does find there that there was a realistic prospect of finding that the test was met back in November 2019. And she takes into account that the threats took place on the 6th of November, the immediate aftermath of the relationship ending, and that's before the disclosure takes place the following day. It's worth remembering here that those threats in the aftermath of the relationship included coming to XGY's grandmother's home in Chichester to throw acid on her face or that of her family members, those of her family members, and that's referred to in the facts of the judgment at paragraph 7. She then comes to summarise her final conclusions right at the end of the judgment. You don't need to turn it up, but it's page 335, where she says clearly that she's striking out all the claims concerning the Hampshire disclosure, and she therefore doesn't need to record in the order which is over the page, at the next tab, tab 20. There doesn't need to be an order for summary judgment because she had decided for summary judgment if she was wrong about the strikeout, but she's already made the strikeout determination.
Yes, and so let's look at what Mr Justice Ritchie did.
Exactly.
Next
So,
call.
Mr Justice Ritchie is at tab 13 of
Yes.
your bundle, my lady.
Thank you.
And if we pick it up at page 144, because this shows his understanding of what we've just looked at. Paragraph 19, third line there, he rightly says that the claims have been struck out, but he then goes on to say, the Human Rights Act, and as far as I can tell, the Data Protection Act claims were dismissed by way of summary judgment for the defendant. That's the middle of paragraph 9. And as you just see, there is no mention of the Data Protection Act claims in the relevant section of the judgment. He actually makes that same mistake a few pages on, and you don't need to turn to it, but it's at paragraph 21.4, where he also adds the common law claim to the list of those dismissed by way of summary judgment. Over the page,
Sorry, what's the point you're making here?
the point I'm making at paragraph 21.4
Yes.
is that he repeats that same mistakes referring to the DPA claim and also adds the common law claim, that's the misuse of private information claim, saying that they have been dismissed by way of summary judgment. As you will have seen, there's been absolutely no mention of them in the relevant sections of Her Honour Judge Brownhill's judgment. So turning back a couple of pages, apologies for jumping around in the judgment, to page 145, paragraph 14, the judge recognises that any appeals from case management decisions, because that of course is what this is, have a high threshold test. And he says that he does apply that at paragraph 17, and I know that my learned friend Mr Goss is going to press you a little further about that. His analysis then starts at page 202 at paragraph 120. That's under the heading summary judgment.
Sorry, but are you saying paragraph 17 of the judgment is wrong?
No, I'm saying it's correct that he was applying the higher, he says that he's applying the higher threshold test, but when we come to see how he actually applies it in my submission, he doesn't do so.
Sorry,
Last line.
paragraph 17, he's saying that these weren't case management decisions, so the high threshold test for case management decisions does not apply.
He says that for the strikeout, the last sentence of that paragraph, he says, in relation to the summary judgment application, I do apply.
Right.
And that's paragraph 17. Yeah.
Turning then to page 202
Yes.
and paragraph 120 of the judgment, he starts there with the observation that Her Honour Judge Brownhill found there was sufficient risk that that the Epsom human rights claims were arguable. In fact, as we've seen, she found that there was a realistic prospect of succeeding. And he then falls into error. He says the only difference between those claims and the April 2020 claims related to the passage of time. That wasn't the only difference, because at that point, DYP knew of XGY's likely location. That's back in November 2019. And he didn't carry out the threats. The Epsom disclosure took place on the 7th of November, and the respondent didn't leave the Epsom address until the 19th of November, some 12 days later. All of this is covered by Her Honour Judge Brownhill's facts, paragraphs 7 to 14 of her judgment. And as well as knowing the Epsom address, DYP also knew her grandmother's address in Chichester and had threatened to go there. None of those threats materialised over the next 5 months. And of course, at the time of the Hampshire disclosure, because fortunately XYG was not staying at her home address, it was with her mother, DYP never knew of her actual location. Still at 120, still at paragraph 120, Mr. Justice Ritchie goes on to list all the pieces of evidence that the judge did not have available to him. And the first is the bullet point at the bottom of that page. Whether K had the ability, that's DYP, he's anonymised him there as K, had the ability to find or communicate with the appellant in that 5-month period. But he did. He knew the Chichester and Epsom addresses. It's important just to clarify one very quick point on this, my lady, which is to apologise that in our written submissions, we have said that it was for the respondent to provide evidence before Her Honour Judge Brownhill as to whether she changed her phone number or blocked DYP on social media. Now, in fact, she had provided that information to the police. We can see it. I don't need you to turn to it, but it's in the summary, the supplementary bundle at tab 9, pages 101 to 129. That's page 101 to 129. There was the evidence before the judge that the respondent had changed her number and had blocked DYP. No evidence in respect of her family members, but in my submission that makes no material difference in a situation where DYP did know her family's addresses and an address where she was in fact living in the immediate aftermath of the threats. He goes on over the page to list further evidence about DYP's emotional and psychiatric state, and in my submission that is conducting exactly the sort of inquiry that Easy Air warns against. Her Honour Judge Brownhill had found that she was satisfied she had all necessary evidence, and it was not enough in my submission to allow the case to trial because something may turn up. This was pure speculation. The first part of paragraph 120 is worthy of close reading. K, DYP, had threatened to kill her and to disfigure the appellant and her relatives by throwing acid on them as a result of her just splitting up with him. There was no evidence about how he felt after he discovered on the 15th of April that she now alleged rape against him. This charge would have carried a far higher prison sentence if proven. The judge found that this undoubtedly would have brought the claimant to the fore of DYP's mind again in April 2020.
I think we can just read this paragraph to ourselves.
You only need to go down to before the court.
Thank you. Thank you. And 122 I've read. Have you? Yeah.
Very good.
Yes.
Great, lady. You'll notice there that he's using the language of a strikeout application, taking the claimant's case at its highest and repeatedly using the term arguable, which is not the test being more than arguable. Arguable or arguably in fact appear in about 15 places when dealing with the summary judgment application. The word just that appears in the second sentence of that paragraph, which you have just read, has two possible meanings. It could, of course, mean just hours before splitting up with him, but the other way of looking at it is with the meaning merely. And if you look at the rest of that paragraph as you've done, you can see that he's conducting a comparison. He's wrongly conflating the events in November, the breakup plus the assault allegations, and comparing them with the more serious, as he sees it, rape allegation in April, which he found far more dangerous with its far higher prison sentence. It is wrong in my submission to minimise the breakup in this way. It is very well documented that seeking to leave a perpetrator of domestic abuse is one factor that can lead to the escalation of domestic violence against women. And if you need any authority for that, you can find it in Kurt and Austria at tab 55 of the authorities bundle, page 1910, paragraph 137. Instead, then, of considering the actual evidence that there had been no contact or attempted contact, he appears to consider whether, in fact, DYP arguably posed a risk to the respondent, when the correct test was whether the appellants knew or ought to have known of a real and immediate risk to her at the time. Paragraph 122, you said...
We've read that.
I'm grateful. He says that there was nothing said about mental suffering as a result of the breaches, but of course we've seen that she did refer to the mental suffering. And of course, again, the test is not about suffering as a result of, and therefore after, a breach. Jumping a few pages to 125, after more criticism about the lack of evidence, Mr. Justice Ritchie decides that it's not right to reach conclusions at the summary judgment stage.
And again, we could read that.
And again, he's given those reasons which are wrong for the reasons I've set out. But he then goes on to say that the only primary evidence was that DC Wells told the respondent it was not safe to return to her Liphook address as a result of the disclosure. That evidence was overlooked. That is, in fact, a gloss on the evidence that was before the court. And that's the moment where I'll ask you just to turn very briefly to the supplementary bundle.
Yes.
It's tab 9, page 108. Sorry, forgive me, page 128.
Yes. Just, I've flagged this actually. Which entry? Just give us
It's
the
log
entry number if you would.
Log entry 114 at the bottom of that page.
Thank you. Just read that to ourselves. Thank you. Yes.
The critical points are that she's told not to go back to the address. She's been staying with her mother since lockdown anyway. And the letter that goes over the page asking for assistance because she is no longer safe there and she wouldn't be able to move on without the knowledge that he could come to her address. That is, of course, not the real and immediate risk test. And there's a critical distinction between an officer taking precautionary safeguarding steps with that high threshold of real and immediate risk. I'm very nearly finished. I'm conscious of the time, my lady. Yes. Paragraph 126 of the judge's judgment, again criticising the lack of evidence and again using the term no arguable prospect, providing the disclosures presented a real and immediate risk to her mental health and her life. And he goes on to give the same erroneous reasons again, saying that DYP did not know how to reach her, but that was wrong in relation to the November disclosure. And finally, at paragraph 135, the judge reaches his conclusion that the Human Rights Act claims were arguable in bold at the top of that paragraph. Finds that Her Honour Judge Brownhill's decision was wrong and inappropriate on the evidence before her. You'll remember that high threshold in easy air, part that we looked at after easy air. He has not applied it here. He doesn't mention it here. Instead, he's dismissive of the judge's justification, which was just that DYP had not assaulted or threatened XGY since November 2019. But that was a major piece of evidence to which Her Honour Judge Brownhill was entitled to give significant weight. He then lists 4 matters. I've already dealt with the first 2. The third one is that the police...
I think again we can read that to ourselves. Yes.
The third of those reasons is that the police's own assessment was high. Her Honour Judge Brownhill didn't overlook that. It appears 3 times in her judgment at paragraphs 8, 38 and 115. And in fact, she explains the point that that assessment of the high risk was made in November 2019 and then never downgraded. And of course, she had found that that risk had dissipated. The 4th point there is the advice from DC Wells to the appellant to leave her new home immediately to avoid the risk, which is why I showed you the supplementary bundle and the actual wordings, which are not to leave her home, but not to return to her home and to stay with her mother, with whom she had already been staying. He dismisses Coroner Judge Brownhill's criticism that the appellant failed to apply for any disclosure in the 2 years as wrong and disproportionately strict, again strictness playing no part of the test. And over the page at 136, he finds it arguable, again not the test, that the judge should have considered the positive and negative obligations under Article 2 and 3. In fact, the negative obligations were never part of this case. The real and immediate risk threshold applies to both positive operational and the positive systemic duty, and she had given proper consideration to those thresholds and had concluded that they weren't met. He then goes on to look at Article 8, abandoning consideration of Coroner Judge Brownhill altogether, and unfortunately substituting his own opinion without any reference to CLG to which she had referred. It was wrong of him to say that the Article 2 and 3 risks and the Article 8 risk were separate from the alleged threats to her life and inhuman treatment. They were entirely premised on those things. My lady, I'm grateful for the extra moments. Her Honour Judge Brownhill's decision was open to her as a first instance judge, and unfortunately Mr Justice Ritchie attacked it on the supposed lack of evidence and without respecting how she had weighed it up. Unless I can do anything on this.
No, you've been very helpful indeed, Miss Wolfe. Thank you very much indeed, Victoria. No. Are you okay to start again at 2?
Yeah.
You okay to start again at 2?
Yeah.
Is 50 minutes all right for everybody if we start again at 2 o'clock this afternoon? Thank you both very much indeed. We look forward to hearing from Ms Parton and Mr Goss later. Thank you.